retrieving my notebook. Yes.
Yes, Lady and Lords, I now have the answer to the two questions that you asked. First, remote working software.
The really important question first. Yeah.
It's definitely not ChatGPT. It means that the witness statement was shared and reviewed digitally and discussed via Teams meeting. The reason.
Okay, well, that's fine. No, don't worry. I don't know why they feel necessary to say that, but there we are.
No, the reason why you see that so frequently is because of a requirement in the CPR, which says that the witness statement must identify the process by which it was prepared, including whether it was over telephone or by.
No doubt we'll have to say that about our judgments too.
Yes.
Yeah.
Yes. Well, Ms Harrison, we'll be looking very carefully at the claimant's evidence to see whether they're CPR compliant. No, I'm sorry, I'm not teasing. If there is a good reason for it, I'm glad to be educated. Thank you.
Say for now, I'll be applying for relief from sanctions.
Second, Lord, the Vice President asked about this court's judgment where provisions in the 2014 Act were considered and
yes, thank you. It's slightly
lawful. I have copies of the judgment if you wish to see it.
I see.
The reference, it's entirely.
Well, I'm sure it's not material on the legal issues.
No, it's not.
But since you've gone to the trouble of getting copies, I wouldn't mind having them. It's just often useful for general background to know the history of the issues about these questions.
And if it helps to clarify that the prejudice that we were concerned with overall was not limited to discrimination. We had a separate.
No, well, I think
Thank you very much.
I made that point, but thank you. Very well. Useful to have that. I'm just making a note. Background only in response to VP question.
Yes.
Thank you very much.
Thank you. So may I now turn to the judgment below?
Yes.
You have that judgment in the core authorities bundle, page 96.
The core bundle.
Sorry, core appeal bundle.
Yep. Ooh. Sorry.
The core bundle is the smaller of the two bundles.
Oh, sorry, we're cross purposes. The judgment below, you mean the judgment in this case?
Yes, judgment in this case, yes. It's in the core appeal bundle.
Oh, is it? Why? Because it's the law report version there.
Core bundle.
Yes, page.
You mean the core bundle?
The core bundle for the appeal.
The core bundle.
Not the core authorities bundle.
Either you're misspeaking or I'm mishearing. It's just as likely to be the second.
Tab 14, FIT 14.
Yes. Okay.
Yes, so I'm so sorry. I don't have tabs, but you have tabs. Yes,
Don't worry about tabs. I mean, I do like tab references where you've got them, but we've all got it. That's important.
Yeah. So this is, of course, a very detailed and full judgment. So I'll take you to the paragraphs that are really relevant to my argument.
Can I just thinking ahead to when we have to write a judgment, without prejudice to the issues in the case. Speaking for myself, I was very impressed by the exposition of the background and the issues and the facts. One way we could do it would be really by saying that anyone who wants the full details can look at that and giving a very much abbreviated account. I don't want to do that if either party thinks there are major errors, but it doesn't look to me as though there are.
No.
Well, watch this space, but we may do it that way because when all this work has been done,
yes.
it seems a pity to redo it.
Yes. Can I then just take you to paragraph 105 of the judgment?
Yeah.
I think everything that the judge said before that paragraph is uncontroversial and with respect quite helpful in detail. So page 122, paragraph 105, there's a heading, what is the source of the power of the Secretary of State to provide those on Section 3C leave with documentary proof of their status and rights. Now, what the judge said at paragraphs 105 to 114 is, in my respective submission, correct. It was common ground before the judge that there is no statutory provision which expressly imposes a duty to provide a hard copy or digital document to those who are on Section 3C leave. The judge refers to New London College, the paragraphs that you have looked at, and paragraph 112, he says that...
Just 1 second.
Yes.
107 is correct, is it? The e-visa scheme, he says, has been extended to some categories of persons with Section 3C leave to remain.
Yes.
Right.
So
Okay.
this is where someone has made a digital application on one of the routes that had been...
Yes, I see. So from the moment they made their application,
Yes.
or more accurately, from the moment they made their application and their current leave had expired, they were on 3C leave, and that would show up because the application would show up. Yep. Sorry, I'm being slow, but that's obviously right. Yep. So where you changed to 115?
Sorry, 112.
112, yep.
The judge says that the power to issue e-visa falls within the range of incidental administrative powers under the 1971 Act. And therefore, the Secretary of State has the power to issue an e-visa. That is, in my respective submission, entirely correct. You may hear from Ms Adjei that it isn't. If Ms Adjei makes that submission, I'll respond to that. But what the judge said was common ground, and that is how the appeal is pursued. The judge then looks at the 2007 Act, Section 5, and the regulations, the biometric regulations at paragraphs 113 to 114. There's no power or discretion under those provisions to issue an e-visa. The Secretary of State the judge says at paragraph 114 that issuing e-visa to those who are on Section 3C leave would not be inconsistent with the 2007 Act or the regulations. That's uncontroversial. Of course, it wouldn't be inconsistent. But that isn't the question. The question is whether not issuing e-visas would be inconsistent with an overriding legislative policy.
Hang on 1 second. Yep, thank you.
So what the judge said right at the end of paragraph 114, that isn't a submission that I made. I'm not suggesting that statute somehow bars the Secretary of State from issuing e-visas.
Yep.
We then go to page 148. And I'm skipping the discussion and the title of the law. You'll see a heading.
So which page you say?
Page 148.
Yep.
Just above paragraph 196, you have a heading decision. And this is really part of the judgment. that provides reasons for granting the relief.
Yes.
The judge says that there are three key considerations why the failure to provide digital document to all those who are in Section 3C was Wednesbury unreasonable. And the first reason is at paragraph 197. The judge says that the evidence clearly establishes that a substantial number of those on Section 3C leave suffer real hardship through being unable to provide immediate documentary proof of their immigration status. And the judge repeats the point at paragraph 199. He acknowledges that not all those on Section 3C leave will suffer adverse consequences, but a significant number will do so. He refers to measures introduced by the Secretary of State, the three measures that I identified, but the judge says, well, but the risk remains.
Yep.
Now my submission is twofold. First, the judge, in my prospective submission, has not applied the principle of deference that arises, acknowledged in the authorities that I've shown you. The Secretary of State's view or evidence was that there was no real risk of prejudice to those who are on Section 3C leave being treated as unlawfully present in the UK.
Well, that's not quite what the evidence is. The evidence is that there was no such risk of prejudice as to, and I forget what the final phrase was. The Secretary of State's evidence wasn't, and I don't think it could be, that nothing ever, that people aren't ever prejudiced.
No.
He says it doesn't happen to a sufficient degree.
Yes.
To require, we if necessary, we can look at exactly what he says. It was
Yes.
Mr. Wright one, wasn't it? At 13? No.
Yes.
10.
Paragraph
10. Thank you. Sorry, remind me which bundle. Here we are.
I think the point you're making, Mr. Malik, is that there's no real risk of those people being treated as unlawfully present. And are you suggesting there's a difference between that risk and the risk of suffering prejudice as a result of not being able to prove that immediately? Or maybe they're the same point. I'm just not clear about that. It's
Yes, it's
subparagraph
paragraph
3
11.
on page 8 of the supplementary bundle, I think, the
Yes,
passage
so
you're
you've
thinking
looked
about.
at, these are, in my submission, two separate points. So you have seen paragraph 10.
Yeah. The phrase was simply act differently.
Yes, there is another part of the witness statement. Yes, it's paragraph 11, second sentence. The Secretary of State does not consider that here that is any real risk that those who have applied for further leave to remain and whose leave to remain have been extended by Section 3C of the 19...
Sorry, forgive me. 11.
Paragraph 11, page 4.
the Secretary of State does not raise any real risk to those who have applied for further leave to remain. Yes, I see.
So he's not saying that, well, there is no risk, none whatsoever. There's obviously a possibility that one person would be treated as being unlawfully present. But as a whole, Mr. Wright is saying that there is no risk. The question for the judge in my respective submission was whether that view was irrational, as opposed to whether that view was right. And the judge should have accepted that evidence. The second point is that even if the finding by the judge that a sizable majority will suffer real hardship is justified, which is
What's
Middle of
sizable
199.
minority? Inevitable, sizable minority.
I'm so sorry, yes, minority will suffer real hardship. But even if that finding is justified, it is for the Secretary of State to decide as to how to address that hardship. Secretary of State took the view that it was not necessary or appropriate to issue digital proof of lawful immigration status to all those who were on Section 3C leave. The judge should have accepted that view.
Well, again, but it's really about timing, isn't it? I think, am I overstating the Secretary of State's evidence to say that she has taken the view that, though not for this particular reason, that it is a good thing, it is appropriate to create a real-time online record for all applicants, which will include 3C leave. But it's a gradual process and she hasn't got there yet.
Yes, but with one important caveat, which is that the view, that view had nothing to do with the 2014 Act or the measures that were put in place. That view was consistent with the long-term vision to digitize things as was outlined in
One of
in
the,
paper.
if I'm not convinced this really goes to the heart of it, but I would be jolly surprised if when deciding whether to spend all their money doing this and seeing what the advantages were and disadvantages, there would be all sorts of advantages for the Secretary of State. But I would have thought one of the advantages that she had in mind was that it would make life easier for applicants on 3C leave who needed to demonstrate their position at short notice.
And their potential employers and landlords.
Yes, and
And the health
it
service.
would benefit everyone. This isn't, and I don't think it's terribly damaging for you to accept that.
No, it's not. It's not. It's just that I'm conscious that there's something in the evidence to say that really wasn't the reason.
Yeah, but
Why?
the trouble is, these witness statements are
Yes. So
forensic documents.
Yeah.
But
the new digital status,
which paragraph are you looking at?
paragraph 13.
Supplemental bundle.
Yes, supplemental bundle, paragraph 13, page 5. Line 10, the new digital status services are not being introduced because there is or had been a systemic issue as to those who are on leave to remain extended under Section 3C. It is part of the wider changes the Secretary of State is making as to conducting certain functions digitally by default.
Hang on one second.
Forgive me, which paragraph were you reading from?
So paragraph
13.
13,
Thank you.
page 5, line 10.
Yes. Thank you.
So the point you're making about the Secretary of State's evidence, does that apply to paragraph 3, subparagraph 1 of Mr Wright's second witness statement?
Yes.
Sorry, I was behind before. If my lady doesn't mind just holding that
No,
for
no.
a second. Where was the first passage that you were referring us to? In para 13,
Yes, line 10.
line 10.
The new digital status services.
Yes, but that sort of general statement cries out for, if it matters, cries out for further analysis. Because, does you mean the primary reason, or because to cover all sorts of relationships? And systemic, what does she mean by systemic? I know that's she does come back to that in the passage which a lady was asking about, which is, where was it?
Paragraph 3, subparagraph 1 on page 8, second witness statement from Mr White.
Yes. Well, I mean, the fact is the statement of evidence is at such a high level here, it may be the correct approach for her to take, but it's difficult for us to get involved in exactly what she, and of course, talking about she is itself a artificial, because these are decisions taken after huge policy decisions among very many people. But speaking for myself, it seems to me that the probability, and there's nothing here that's inconsistent, is the Secretary of State was aware of all sorts of advantages of introducing a digital system. I'd be surprised if she wasn't aware of advantages for applicants for further leave, just as much as one of the advantages. And the real question is not really to do with that. It's to do with whether it could have been done, should have been done rationally sooner than it was. Whether because of those problems.
The Secretary of State isn't. The claimant's case isn't contrary. That doesn't address the claimant's case. The paragraph, the sentence you've just read. The claimant's case, as I understand it, is not that it was being introduced to address a systemic issue, but the way in which it was introduced created prejudice to Section 3C people, and undermined the purpose of the overall purpose of the immigration legislation.
Yes, I mean, no issue with that formulation. The submission, my lord, that I was seeking to make was that the first reason the judge gave for finding that there was Wednesbury irrationality, unreasonableness, was that a sizable group of people will suffer real hardship if there is no way for them to evidence immediately their immigration status.
That's just playing with words. How much is sizable? What hardship is real? Sorry, I want to reformulate your case for you. I'm trying to think it out. Isn't it really more about the Secretary of State made a judgment that the incidents which she should have been aware occurred of from time to time, people being prejudiced, people like Ms Adjei, but other examples in the evidence as well. Her civil servant can't have been unaware that sometimes happened. And the real defence is the problems were not of such a scale that we should have done what we did earlier in order to address that problem. It's an evaluative judgment of the scale of the problem against the what seems to be what would otherwise be the natural pace of introduction.
Yeah, but
That, I know that's not quite how you put it, it's not quite how she puts it, but on analysis, isn't that what the real criticism has to be?
well, accepting that would essentially amount to a concession that, but for these changes, the default position was witness-free irrationality. And I, with respect, do not accept that. The submission is that it was for the Secretary of State to decide how to address real hardship, and even if she had
Yes.
not taken any steps that she had, there would have been no witness-free unreasonableness.
Yes, I didn't mean to imply the answer to my question. I was really trying to formulate what the question was. I obviously see, if the question was as I think I formulated it, you say, well, fine, but that's just the judgment of the Secretary of State's job to make, not the court's.
Yes.
It's just I slightly rebel against the idea that they didn't think there was any hardship at all. She ought to have known there was some hardship.
Yes.
The real question is an evaluative one about how much hardship was necessary for it to be, whether the hardship was of such a scale
Yes.
that she should, as a matter of rationality, have acted quicker than she did.
So no, yeah.
You don't like that still.
No, I do not, with respect, accept that. And,
Okay, fair enough. Yeah.
The reason is that, yes, so the Secretary of State considered the difficulties, took into account the mitigating measures that she has adopted, and took the view that no further action was needed, none whatsoever. The fact that she is
Yeah.
digitalizing things is pursuant to a different policy, and the incidental benefit of that policy is that it provides benefit to employers, landlords, and to those who are on Section 3CD. So that means that even if the Secretary of State had not done what she started doing in 2021,
Yes.
that would have been unobjectionable.
Well, I see why you want to fine tune the way I put it, but I'm not sure that's.
May I ask a question, please? In subparagraph 3.2 of the second witness statement, Mr Wright refers to paragraphs 12, 13, 46 as the detailed grounds of defence.
Yes.
And I've just been looking at those, and paragraph 46 of the detailed grounds of defence, which is page 241 of the core bundle, refers to a policy paper, New Plan for Immigration, Legal Migration and Border Control Strategy Statement 2021.
Yes.
Was there any argument or discussion about that before the judge?
Yes, lady. If you go back to page 5 of the supplementary bundle and see the first statement of Jonathan Wright.
Yeah.
So it's paragraph 13 where he refers to that document.
Yeah.
And this is where he explains the premise on which the new idea
I
was
see.
deployed.
Yeah. But there was no challenge to that plan by anybody.
Was the document itself? Was it in our bundle? I haven't seen it. Or was it before the judge?
It was before the judge. It was attached as an exhibit to the statement.
Oh, I see. Of course it was. Yes.
Yes, but it's not included
We
in the
haven't
bundle
got it.
because it's summarized at paragraph 13 of the witness
Yes.
statement.
Okay.
But sort of fundamental, the broader point that really matters for the purpose of my argument it is that it was for the Secretary of State to exercise a judgment as to how to address hardship, not with respect for the court.
Yeah.
So that is,
Hang on just a second.
yes.
Your key point, just to make it more neutral, not tie you to my formulation, but the judgments involved are properly only for the Secretary of State. Then you needn't bother about exactly how you formulate what the decisions were, whether it was to do nothing or whether it was to introduce the digital online record earlier.
Yes.
Yeah.
I'm very grateful. So that is the first point the judge made. The second point the judge made is at paragraph 202, page 149 of the court bundle. In my judgment, the judge said, it is clear that the legislative purpose is that those who are on Section 3C leave should be able to immediately demonstrate that they have such rights and entitlements. I have, Lady Lords, made submissions on the legislative purpose. That I say is not the legislative purpose of Section 3C. But this point is linked, and I've taken you to Akinola already, but this point is really linked with the point that is made at 203. Just right at the end of page 149, it is absolutely clear, the judge said, that the parliamentary intention was not only that migrants awaiting determination of their applications should be entitled to remain in the United Kingdom, but they should also be entitled to remain here on exactly the same terms. Exactly the same terms is the phrase that the judge used.
Well, exactly the same terms as regards benefits or entitlements.
Yes. And yes, but that, for the reasons I have given, wasn't Parliament's intention. Now, it's not with respect entirely clear what the judge had in mind when the judge said benefits or entitlements.
Well, I think it's reasonably clear, isn't it? It means that they would be entitled to rent private property. They would be entitled to, I don't think he was talking about social security benefits and so on, which they might not be entitled to anyway. He was meaning the absence of let or hindrance, really. Being entitled to rent property, being entitled to work, being entitled to NHS care, those sorts of things. That's how I read it anyway.
Yes. The submission that I make with respect is that the judge there simply disregards the sort of four fundamental differences between Section 3 leave and Section 3C leave. Parliamentary intention wasn't to put those in exactly the same position.
Well, as regards benefits or entitlement, that is quite an important qualification.
Well, if benefits and entitlements simply mean right to rent, work, continue on the same terms as previously, that's not objectionable.
Well, do you accept if it's confined to benefits and entitlements in that sense, that it was clear that was Parliament's intention?
Yes. 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 Yeah. But the submission that I make is that the judge and it will become clearer once we look at subsequent paragraphs, that the judge effectively said that those who were on Section 3C leave, Section 3 leave and Section 3C leave were effectively in the same position. And
That statement is absolutely clear. Statement at the bottom of 203 is his riposte of his reason for rejecting your submission, that the sole purpose was to allow people to stay while pursuing applications.
No, I mean, of course, I accept that that isn't the sole purpose. Well, it isn't the sole purpose of Section 3C. I accept simply to prevent abuse, annualize the authority on the subject. But you have my. I mean, if you read that paragraph, that sentence in the way that you have provisionally read, I have no issue with that.
You're taking a run up to the first part of paragraph 204, are you?
Yes, but yeah. So you look at then the next paragraph. So the judge. So I've addressed that paragraph 204, in my skeleton argument at paragraph 31. So the measures in the 2014 Act do not distinguish between, as in my submission, the judge thought, documented and undocumented migrants. The measures seek to restrict access of migrants with temporary permission who have some sort of immigration status, but if they are not allowed to work, then it matters not whether they are documented or they are not. Middle of that paragraph, it is in my judgment, paragraph 204, it is in my judgment irrational that the legislation, and specifically Section 3C, is intended to protect rights and entitlement of those with Section 3C leave, but leaves them with no way themselves of demonstrating that they have such rights and entitlement. This, in my respective submission, is a criticism of legislation. Well, Section 4 says that you've got to have a written notice if Section 3 leave is granted, but the legislation does not have an equivalent for Section 3C group, and that is irrational. But that is the consequence of primary legislation. And then end of that paragraph, the judge said, well, a simple and straightforward way is to just issue documentary digital proof to everyone who is on Section 3C leave. It is not simple and straightforward. In fact, the evidence was that it was just not possible to issue e-visas retrospectively to those who have made in-time paper applications. The judge there is, in my submission, conducting a merits review of the situation. Paragraph 205, last sentence, I have made my submission on the M versus Scottish Minister's case. There's no legal right to a notice in writing or a documentary proof of residence if someone is on Section 3C leave.
Can we go back to 204?
Yes.
You skated over the first part of 204. Which part, if any, of that paragraph do you say is wrong? I mean, do you accept?
No.
Do you accept, as he did, Ms Harrison's submission, that the framework of immigration legislation is underpinned by the objectives and purpose of the compliant environment policy?
Yes, so that is not controversial, but
and that it's not just policy but embedded in the legislation.
Yes, so that is. Isn't
How about the next sentence?
Yeah, that is, and I've addressed. So there are three errors in my respective submission in this particular paragraph. The first relates to that particular sentence that you're looking at. The compliant environment
Which
policy.
sentence is that? Just tell me again.
Sorry, the compliant environment policy is
Predicate. It's the third sentence, isn't
Third
it?
sentence, yes.
That's the one you. That's where you say he went wrong.
Yes,
In this
so-
paragraph.
and paragraph 31 of my skeleton, I've addressed that.
Yeah. Yes.
Secondly, where the judge says it is irrational that the legislation does not. The legislation intends to protect rights of those who are in Section 3C, but leaves them with no way of demonstrating that they have such right.
Yeah.
Criticizing legislation, and then finally, in the final sentence of that paragraph, the judge said, "Well, a simple and straightforward way is to just issue digital proof to all those who are in Section 3C. The judge is conducting a merits review, substituting his own views, and plus, it isn't simple and straightforward. It's not possible on the evidence. The judge in my submission there entered into forbidden territory.
So where does he say simple and straightforward?
Right, the last sentence at paragraph 204.
Oh, of course, yes. Thank you. I mean, the logic of that reasoning is that digital online records should have been applied since 2014.
Yes.
And yet there was no evidence that it was possible to have digital online records in 2014.
That is right, yes. So that is 204 and my three submissions on paragraph 204. Paragraph 205 is where the judge rejects the submissions based on Patel and relies on M versus Scottish ministers. You have my submissions on that. There is no legal right, as the judge thought, to have a written notice or proof of leave under Section 3C.
So the reasoning in that first sentence is a little bit unclear to me. Because again, the judge seems to be, I don't know, is the judge criticising the legislation?
This is the first sentence of
Yes, I'm just not quite sure what point he's making.
paragraph 205.
Yeah.
Yes.
Because the legislation itself doesn't provide for documentary proof.
Yes.
And then he says it's not just an incidental effect of the statutory provisions, which is right. And it may go back to the point that you made earlier in relation to paragraph 204, that the
Yes.
judge is there criticising a lacuna in the legislation.
Yes. So that is the submission, and there's no legal right to a document.
But it goes further than that, doesn't it? A document saying that you are on 3C leave is as soon as you start thinking about it, is a useless document.
Yes.
It will be issued on a particular date, would state the position on that date.
Yes.
And no one would know whether it was true a week later or a month later. Yeah.
Well, it must mean the digital. Does he not mean the digital record?
Yes.
Which doesn't have those features.
Well, yes. He ought to mean that, but I'm not sure he has that in mind.
Yes, I've put in the margin next to it as he left out the word immediate, because that's what he wants.
It says it earlier. He does say immediate at an earlier point, doesn't he? I forget.
Well, sometimes he says immediate and sometimes he doesn't. So 205 immediate's missing. It's also missing from 203.
But there's no such thing as immediate. Unless you have a digital online record,
Yes.
then if there's reason to believe that's available, and then you just come into judgmental questions about timing and pacing and so forth. The only alternative is to have a system whereby you can go online and ask.
Yes.
And that will never be instantaneous.
Yes.
Even if it's 2 days. 2 days may be enough for you to lose your job, or lose your job offer, or lose your tenancy.
Well, is that how does it work? How does e-visa work? What do? Do you show up your mobile phone with with a record on it?
Yes.
In which case, it's to use the word he uses it in the last line of 204. Instant is instant, isn't it?
Yes.
Yes. Instant is key.
I mean, isn't trying to, as it were, look at it from the judge's point of view, isn't, whenever he talks about documentary proof in these paragraphs, isn't he really talking about instant evidence of the sort which he says in the last line of 204?
I think in fairness, yes, he is.
It must be.
Yes, that must be right. So,
Well,
But-
I don't want to go behind your concession, but it's not so much. I think if you asked the judge, he would appreciate that. It's inherent in his whole reasoning. But I just wonder whether he loses focus from time to time,
yes.
which we all do. I mean, and whether what he says in 205 actually does focus sufficiently on the fact he's talking about instant proof.
Yes.
Instant demonstrability, because that's now what the appeal is about, and what the case, in fact, also what the case is about on his own analysis, because he very early dismissed
Yes.
the idea that a letter would be good enough.
To be fair to the judge, the last sentence of 205 does use the phrase without delay.
Yeah.
I mean, of course, if you, yes, just reading that paragraph in isolation just wouldn't be coherent and wouldn't make sense. So I think it's fair for me to accept that.
That this passage in this passage as a whole, even where the word immediate or a similar phrase is missing, the judge intended it to be there.
Yes.
Yeah.
We also have to bear in mind, don't we, that when the as it's now called compliant environment policy came in, or the hostile environment policy was formerly called, came in, we didn't have digitised records. We didn't have instant access.
Yeah.
So when he's talking about the underlying,
Yeah.
the fundamental, whatever phrase he uses, the objectives and purposes of the legislation and the policy,
Yes.
the underlying purpose of the legislative framework, is he talking about it now or then? And has it changed? Has the policy changed? And the framework changed, the underlying framework, policy change, whatever phrase you like to use, changed as a result of the digitisation?
Yes. No. The logic, of course, of the point that he's making is that there should have been measures in place in 2014 enabling someone to demonstrate their immigration status instantly.
Yes.
But I think ultimately the reason why he granted the declaratory relief was that, well, you have e-visas for Group 1.
You have them now.
But
I
why
mean,
not extend it?
I'm sure you're right about that, but I do think it's an important thought experiment
Yes.
Yeah.
to say what was the position the day after the hostile environment? Was there a reviewable lacuna
Yes.
in the legislation or in the in the Secretary of State's decisions, because he had imposed all these restrictions without providing for instant demonstrability of the status of people on 3C leave.
Yes.
we'll have to hear Ms Harrison about that. But if the answer is no, at that stage, you just had to do the best you could, and the best you could was to have as efficient a system as you could, whereby people could choose could get information within a short time, understanding that would still be too long in some cases. If you say, well, that was all right on the state of technology or the state of then, well, then it all becomes about timing. It all becomes all right, but is it evident that by 2024 there should have been a system in place for everybody?
Yes. Because
you've got one in the pipeline which will eventually solve the problem, and you should have done it earlier. That I made this point this morning. I can't help feeling that isn't the real criticism here. To which, if it were, as I understand it, your answer is it must be for the matter of the Secretary of State at what pace to make these changes, and his decisions, her decisions, should not be held to be unlawful unless the pace at which he or she has done so was irrationally slow.
Yes.
Which would be very slow, very difficult thing to prove. Given the state of the authorities, would be a very serious matter for the court to decide, although theoretically possible.
Yes. But of course, I do make that point with respect, but that point is based on a hypothesis that change was required as a matter of public law obligation, and the submission that
I know that, but I mean, at this stage in the argument, we're focusing on what the position is if there is a real problem for a lot of people, which could easily be solved. Then you might well be in Johnson territory. Why hasn't the Secretary of State done it? You would, but
yes, no, yes.
There we are.
Well, yes. The question, of course, would be whether it is irrational for the Secretary of State not to have done.
Yes, no, I understand that.
But I take the point. So, of course, I'm conscious of the time.
Yes, thank you. No, it's not your fault. We've just been exploring matters with you.
Okay.
Yeah, keep going. Yeah.
Just move to the third point the judge makes. The judge accepts that a hard copy or a paper document is not practical, paragraph 209. But then at 210, that refers to the intention to digitize all routes, and then makes the point that, well, there is no evidence from the Secretary of State that there are reasons of impracticality or expense as to why the Secretary of State would not take this straightforward step.
Yes. So where are we now? Sorry,
210.
210. Towards the end of that paragraph, no evidence of impracticality or expense. Well, the evidence from Jonathan Wright, first witness statement, paragraph 13, last sentence, was that it just isn't possible to grant e-visas retrospectively to those who have made paper applications.
Yeah. I mean, that may be the reason why you're being resistant to my saying this point is all about timing. Because the judge did confront that, and he said that the Secretary of State hasn't put any evidence about timing before the court. If the Secretary of State has said these digital onlining really only became practicable in 2013, and then we had to pace it and so on, then claimant would have been in real difficulty.
Yes.
But he says it's basically saying the burden of proof is on you to show why you couldn't do it.
Yes.
And you have to say there was nothing we needed to address in the first place. Yes, okay.
Yes.
Needed as a matter of law to address.
True. That's it. And then paragraph 211, the judge repeats the phrase, a straightforward step to avoid hardship for a substantial number of people with no negative consequences for the Home Office or for the immigration regime. At the end of paragraph 211, it isn't a straightforward step. It is a step that is not possible on the evidence from Jonathan Wright. Second, the judge again, in my respective submission, goes into forbidden territory. It is for the Secretary of State to decide what step is straightforward.
Well, Jonathan Wright says what Jonathan Wright says is not possible is that it's not possible to issue an e-visa or an online record, I should say, to people who have not made an online application for an e-visa.
Yes.
But at the judge's point, I think is yes, but you should have made it possible for them to make an online application for an e-visa by way of further application. You should have made it possible long ago.
Yes. Yes. Well, I'm not sure with respect if that is the point the judge is seeking to make. But if he is, then he then clearly drifts into forbidden territory.
Yeah.
And then I've taken you to the evidence that what the segment. I mean, this is really the timing point that you've made. So assuming that I'm wrong about everything that I've said, Secretary of State's evidence was that she's doing it in a sequential, gradual manner, and the judge's judgment simply abruptly interferes that scheme. Paragraph 212, the judge deploys Johnson, and you have my submissions that isn't the appropriate approach. Just one final reference, that is paragraph 215. Well, the judge says that I do not fall into the trap of filling a perceived lacuna in the legislation by judicial activism. The state force with respect. This is precisely what he has done.
Bit of a loaded phrase, judicial activism, though, isn't it? You wouldn't. I'm sure you didn't put it like that.
No. I mean, it's just that. I mean, the judge. Sorry.
Although you say it's what he said, that's not how you.
Well, that's what he said. But
In the climate at the moment.
he saw a lacuna in the legislation. If you have Section 3C leave, the legislation says, well, grant written notice. But the legislation does not say grant written notice if you have Section 3C leave. That is the lacuna that he saw, in my estimation, sort of fill it by deploying Wednesbury, and that was wrong in principle and wrong in law. So unless I can assist you any further, these are my submissions on the principal question. I'll be very, very brief on the second question. I think we'll hear from a learned friend, but not entirely sure if the second ground is entirely sort of freestanding of the first ground.
Well, as you say, we'll have to hear how she puts it. There's obviously some overlap, I'd have thought.
Yes.
We'll see.
So very, very briefly, can I just quickly take you to the relevant statutory provision? You're familiar with Section 55. In the Supplementary Authorities bundle, it's behind tab 5. A common error in my research submission is to assume that this provision requires the Secretary of State to take into account welfare of the children in making any decision. It does not. The obligation under subsection 1 is to make arrangements, nothing more than that, for ensuring that that happens.
I've had another case recently in which meaning of make arrangements was in issue. I think it's one in which judgment is pending. You're not aware of any reported case specifically on this? Okay.
So the obligation is to make arrangements for ensuring that functions listed in subsection 2 are discharged having regard to the need to safeguard and promote welfare of children. That duty was discharged when the Secretary of State published the statutory guidance, which you have behind tab 7. And this guidance applies to all functions, immigration functions of the Secretary of State. And the paragraph that is relevant for present purposes is paragraph 2.7, which you have at page 54. So the agency must act according to the following principles. The agency, of course, no longer exists. Functions were replaced by UKVI in 2013.
When was the change, sorry?
In 2013, when UK border agency's function were transferred to
UKVI.
UKVI.
Yep. And UKVI is in fact not an agency, it's simply a section within the Home Office, isn't it? Constitutionally a different kind of animal. Yep, okay.
So this is the statute and this is the policy. So whenever the Secretary of State is making a decision about children exercising any function, there is an obligation to apply these principles. The best interest of the child will be a primary consideration, not paramount consideration or not the only consideration. So if in a particular case there is a failure to follow these principles, the individual would be able to go to court, apply for judicial review to say that, well, failure to make a quick decision on my application is unlawful because I have a child, for example, and the welfare of the child requires a quick decision. If I'm not issued with a proof of my residence, that would be unlawful.
So section 50, is this right? Your submission is that the only effect of section 55 is, in practice, I mean, it makes arrangements by issuing the guidance.
Yep.
Section 55 then falls out of the picture. All you do is when there is an individual decision, which it is said doesn't treat the interest of the child as a primary consideration, you can judicially review that decision on that ground for not following the guidance,
yeah,
which is itself one of the arrangements, which is itself the arrangement required by section 55. Is that how you put it?
No. So not only a decision, but I would accept that it would extend to a policy.
Yes, all right, okay.
A decision.
Fair enough. But you judicially review a particular policy or a particular decision on the basis that the policy was arrived at or the decision was taken without considering the best interests of the child.
Yes.
Yes.
And that would be amendable to challenge, and the courts have frequently said that policies are unlawful because they are sort of inconsistent with the guidelines.
What's the most recent Supreme Court decision involving section 55? It was central, wasn't it central to
Yes.
the Britsits case?
Yes. So the nationality case, project for registration of British citizens, no, that's this.
That's the one. Is yes.
Yes.
But that is there any? There's no extended discussion of how Section 55 works in that case. Well, the sensible thing I think is this is Ms Harrison's cross appeal.
No, it's not.
Oh, it's not. No.
It's the second round appeal.
Second round of appeal. So sorry, you're quite right. It's not a cross appeal.
Just to make things simple, I mean, I do not want this appeal to get any more complicated than it is. The Secretary of State has an obligation to have regard to welfare of children in exercising any function. That includes making decisions in individual cases and also formulating policies. That is the position.
Doesn't that, you say it doesn't add, at this point, doesn't add anything either way to the analysis, really?
No.
It all turns on ground one.
Yeah.
And what is Miss Harrison's cross appeal?
Yes. So I can then just quickly show you how the judge dealt with this. Two short paragraphs. Page 165 of the core bundle. And the real reasoning is at paragraph 250. And this is, in my submission, entirely premised on what the judge said about the principal questions. If I'm right about round one in my respective submission, that
I see.
would mean that I succeed in round two as well.
Sounds awful.
If the Secretary comes up with a new policy and fails to have regard to welfare of the children, that would be unlawful. But for the reasons I've given, there's no illegality here.
Right. Well, I was obviously wrong to say it's Miss Harrison's cross appeal. It may well be that it will be easier for us to come back to you in reply when we've heard how the points developed by Ms Harrison.
Thank you. I'm very, very grateful for your patience. These are my submissions, unless there are any questions.
Oh, actually, I just have one. Is there any point at which it's too early to apply for a variation of your Section 3 leave? I wasn't clear whether there is, because it seems from the evidence as though more or less everybody applies virtually at the end of their Section 3 leave for a variation or an extension. Is there something that compels them to do that, or?
No. So you can apply for variation of your leave at any point. So you do not have to, I mean, for example, if someone is here as a student...
Essentially, variation includes extension.
Yes,
Yeah.
extension. So if you are here as a student, your leave is valid until 2028, but you now have enough funds and you want to become an investor, so you can apply for leave at any point. But if you want to apply for further leave to remain as a student, the guidance says that, well, you make an application no earlier than 28 days before the expiry of your leave.
And also, both human nature and practicality mean that in that case, you won't want to do it too far in advance.
Yes.
Well, human nature, because people do tend to leave things to the last minute. But practicality, you will want to make your application on the basis of the most up-to-date information.
That's right. Yes.
And if it's a student, you'll want to, you may not know until quite soon before your current leave expires what kind of studies you want to do in the future. So inherently, they're likely to be towards the end of the period.
Yes, if the extension that you're seeking is in the same category.
Yes.
Yes. Whereas if you're applying for variation to do something else, you can apply whenever you like.
Yes.
Okay. Well, that's very helpful because I didn't not sure the judge expressly deals with that, and I just wanted to know what the answer was.
Very good.
Thank you.
I just have one question I just want to think through before I put to you. Yes, suppose there had not been a stay, or you were not appealed. What would the practical effect of the declaration granted by the judge have been?
That would have placed the Secretary of State in an impossible position. The practical effect of the declaration would have been that the Secretary of State would have been under an obligation to create e-visas for everyone who is on Section 3C leave. That on the evidence and my instructions was just not possible.
Well, I think one can easily see that. Take judicial notice of it. If you haven't got a scheme in place that does this, we've got some evidence about how the scheme. You can't just immediately do something that you plan to do in 5 years' time or X years' time. I mean, again, Ms Harrison can deal with this, but this just does show that sometimes declaratory relief stops people really focusing on what the real problems are. Normally, we say, well, you no need to have mandatory relief against Secretary of State, because if they're told what they're doing unlawful, they'll now, or what they're not doing is unlawful, they'll immediately do what they're supposed to do.
Yes.
But that's not always possible.
Yeah.
And then you get the case, well, what happens?
Yes, I mean,
and if we were to dismiss the appeal, the same problem would. If we were to dismiss the appeal, yes, the same problem would immediately arise. What are we actually expecting you to do?
Yes.
What they've said they will do.
At that point, possibly the evidence you weren't allowed to put in for the substantive appeal might be essential, because we need to know what kind. The court doesn't order people to do things that are impossible.
Yes, I mean, ultimately, the Secretary of State will put everyone on e-visas.
Yes, but the key word is ultimately.
Yes. So the stay application wasn't made lightly, and I do, put the case as forcefully as this, that it just wasn't possible.
There was presumably some well, my lady granted the stay and will remember, but I'm afraid I haven't looked at this. Was it supported by witness statement or simply by submissions?
No, simply by submissions. I think there wasn't any evidence.
Okay. Well, let's not. Okay, I just wanted to flag that as an area that I think creates real difficulty.
Very good.
Hang on one second. Thank you very much, Mr. Malley.
My lords, my lady, in responding to the Secretary of State's appeal, what I would like to just identify first is obviously we've identified what are essentially the three issues: whether or not the judge below erred in law in concluding that the Secretary of State's failure to provide digital proof, and when we say digital proof, that means a method of recording information, which can be electronic or in writing, but that's from the definition of Section 15 of the 2007 Act.
Sorry to interrupt you in your first sentence.
Yes, of course.
As a matter of statute, it can be electronic or in writing, but to meet your substantive case, it's got to be an online. It can't be a document in the sense of a piece of paper. It's got to be a constantly updated online record, hasn't it? That's the core of your case now.
Yes, your lordship is right that our case was that it could have been a physical document, because in fact physical documents are issued to other persons subject to immigration control whose leave is not yet determined. So just to make that clear, so for example, those who apply for pre-settled status under EU law retained provisions, whilst their application is being determined, they are issued with a physical document, even though there's no time end for it. Similarly, for those who are asylum seekers.
But if they are issued with that, it's very unclear how it helps, because it'll have the date on which it was issued, and anyone saying, well, is this valid now, won't have an authoritative answer.
Well, I'm just saying to you what the position was, which is that that does operate already for certain categories of person who have applications outstanding, those who are applying under EU provisions or asylum seekers. That was the basis on which we said those with 3C leave could be issued with a document on the same basis. It will be time limited, and it may need to be extended. So that is the scheme in terms of physical documents that we said was analogous to this situation. We accept, and the judge considered this, and rejected that as the solution. So the only issue before the court is the question of a digital document.
Yep.
And because it is important to the case, it may be just to start from looking at what that means in section 15 of the 2007 Act, just so that when we're looking at the declaration that was granted and to which the appeal is focused on, that we just look at what that means. So,
sorry, just give me one moment. I'm sure you're right. I just wanted to see though what your what the order says.
yes.
Does it use the word document? I thought it used
does.
the word
It says-
record. Digital document. You're quite right. Okay. Yep.
But what a digital document means, if we just go into the Supplementary Authorities Bundle, section 15 of the 2007 Act, and 15(1)(d), a document can...
Sorry, where are we? Where, is this in the authorities?
Supplementary Authorities, additional Supplementary Authorities.
Okay.
That's two.
Yeah, wait. We better
A
get
small one.
A small bundle we provided you with
Yes.
yesterday. Apologies for the timing of that.
Yeah. Which tab?
Tab 4, my lord. I think my learned friend has taken you to it, but it just helps because from here on in, when we refer to digital document, this is what we mean. And you'll see that at 15D, there's a definition in the statutory scheme whereby document includes any other method of recording information, whether in writing or by the use of electronic or other technology, or a combination of the two.
How does it help to look at that, though? That's a definition which is much wider than what we're talking about here, because it includes card or sticker and a method of recording information by any means. Surely you're meaning something much more precise than that, aren't you?
I'm meaning a document, meaning a method of recording information by the use of electronic means. So that's
Yes,
what I mean.
Well, but that would mean a static entry on a computer screen, which wasn't regularly updated.
Well, the digital, we know that that system, the digital recording of information on the Home Office's computer is updating and is instant. So that's what that means.
But that just
Well, okay, that's good, and I agree with you, but I don't think it helps to look at the Borders Act, which wasn't even dealing with this, is unhelpful, isn't it?
No, only because I'm only doing that for this purpose, which is that when we say digital document, I am confirming what your lordship has put in discussion, is that using the statutory definition of what a digital document means, which is a electronic method of recording information, that information will be in real time. What the situation is now is what we're concerned with here. So that's what that means.
So in other words, you're adopting the definition in section 15, which is actually in terms a definition simply for the purposes of section 5, which deals with registration regulations, which aren't directly relevant, but you're simply adopting that.
Well,
definition.
I don't say they are directly relevant, because those we'll come on to that, but section 5 and 15 and the regulations are a source of power for the Secretary of State to issue or to provide a digital means of proving your lawful immigration status. That's what it does. When we look at the regulations, that's the power that the Secretary of State already has
This claim wasn't based on a suggestion that the Secretary of State should have made different or better regulations.
The sole question before the court below was, is there a, or not the sole question, but a central question for the court below was there a source of power by which the Secretary of State could provide a digital document using that in those terms? The answer that the judge gave below, which I accept is recorded as common ground, was the new college means. But what is also clear is when the judge addressed the question of Section 5 of the 2007 Act, he, by mistake, we're both responsible for that, he thought that only related to written documents, whereas in fact it's clear from Section 15 that this statutory scheme also provides for the provision of digital documents as well. So he proceeded on a misunderstanding of the limited scope and what he perceived to be a limited
speaking
scope.
myself, Ms Harrison, I think we've got into this by way of a digression on a digression. You're going to make a submission about this in due course.
I am, yes.
And I think let's deal with this at the right stage.
Yes.
We got into it, and I think this is where we can get back on track. You were simply saying what you meant by a digital document, and you were confirming that now, on this appeal, what you are saying you want is an online, continuously updated record, online, therefore, and accessible, continuously updated record.
Yes.
And you say that it's helpful to look at the Section 15 definition, even though it doesn't apply. I'm not sure I agree about that, but it doesn't matter. The important thing is what you mean, and we agreed about that.
Yes.
Yeah, good.
That's the starting point
Good,
on the declaration.
Well, let's get back to where you were intending to go.
And we say that the judge came to a lawful and correct conclusion in making that declaration, that the failure to provide such a digital document was Wednesbury unreasonable. You will also have seen that in our cross-appeal, we cross-appeal on the basis of the alternative submission that was advanced, which was a Padfield submission, and we have permission to argue that ground. And in that respect, I will obviously take the approach that my learned friend did, which was to deal with those together as alternative submissions because they rest upon similar reasoning and looking at the evidence. We do also say that the judge was correct to conclude that there had been a breach of Section 55. It is not sufficient simply of the Orders Act 2009 simply to issue guidance. The judge in the alternative was correct to make the declaration that he did in respect of that. The critical basis upon which the court granted permission to appeal was on the basis that there was an absence of express power to make the provision that we sought, i.e. a digital document. It will be our submission that there is an express power. We say that express power can be found in the 2007 legislation, but if not, it is clear that the power derives from Section 1.4 and or from the ancillary powers that were identified as in existence, which it was common ground from the new college case. And that ultimately the source of the power does not determine or undermine the reasoning that the judge gave in concluding, after a very detailed exposition of the law and facts and evidence, taking account of all the concerns that are addressed about the questions of a high hurdle, deference, the complexity of the situation, all of those observations that are made in the legislation, in the case law about the court's jurisdiction to determine whether or not an action taken by the public authority is irrational. He was fully aware of all of those matters, and he came to a conclusion based on his evaluation of the evidence which was open to him, and similarly his exercise of judicial judgment based on all of the material and the submissions that he heard. Now, I know the court will be fully familiar with the limits of the scope of the appeal that we have, but it is important to reiterate the provisions of CPR 52.211. This is not a review. This is only a review. It is not a rehearing. The court will only intervene if it concludes that the that the judgment below was wrong, and in that context, wrong must mean that where it rests on any findings of fact, that is unsupported by evidence, or it is a decision where no reasonable judge could have reached it, and on that basis it would be necessary to demonstrate.
If something is irrational, that's a decision of law.
Yes.
And it's binary. It either is irrational or it isn't.
But
You can't say, well, a reasonable judge could have decided this was irrational. That's not, in a Wednesbury case, that's not possible.
Well, you would have to ask, has he properly directed himself in law in applying the correct test? We say, yes, he clearly did. And in his evaluation, which is a matter for the first instance judge, applying the correct test.
Rationality isn't a matter of evaluation. Rationality is a matter of law.
Do you mean the factual basis upon which he exercised his assessment of rationality, insofar as he made findings? They were for him. Is that your point?
Both, my lord. Certainly on the basis of the factual underpinning for his assessment, that is a matter for the court, for the judge, subject only to that being demonstrated to be irrational. But ultimately, this is an area in which there is a exercise of judicial discretion and evaluation, judgment, that a first instance judge's assessment of that, because he hears all of the evidence and analyses it in a way that this court plainly cannot and does not. It doesn't have all the material that he had. He had 1,000 pages of additional material that's not before the court.
But all the material stuff is summarised in the first 100 paragraphs of his judgment.
Which he does in a detailed
He does, absolutely. But if we start with all that,
yeah,
accept all of that, and say that on the basis of those findings, he was wrong to find that the Secretary of State, well, put it another way, we accept all of that, we still have to say, was he right to say that the Secretary of State acted irrationally? That is a binary question, not one on which we can say, well, we probably wouldn't have decided that, but it was a matter of judicial evaluation. That's a proportionality test, which we're not in proportionality territory unless the Supreme Court changes the law.
We're not, but we would say that an evaluation on proportionality, which is also a question of law, similarly an evaluation.
Well, I'm not sure it is.
Well, but it has similar elements to it. It ultimately rests upon, once the judge has properly directed himself as to the correct test, his application of that test to the facts and context before him is one, we say, in which this court should not should adopt the approach of concluding that it would only be appropriate to intervene on appeal if that evaluation could be demonstrated to be outside of what was a reasonable possibility. It is his evaluation based upon all of the material that he had. And in those circumstances, we say that the court should, as it often does, remind itself of its limited function on an appeal.
It absolutely does, and it's very important, but that isn't true about points of law. Points of law, you may say, well, there's a reasonable argument both ways, but you've got to make up your mind. The points you're making are all very important about matters of discretion and evaluation, but I'm just wondering whether this is really a case about discretion and evaluation. But you say it is.
Yes, I think it may be that one authority may be worth looking at. If we go to the supplementary authorities bundle and look at the tab 9, beginning at page 40, it's the case of Z and another Hackney Borough Council, which was a discrimination case.
Do you mean the supplementary?
Yes, please. Yes, please.
Not
If
the
I call that supplementary too. It addresses the role of the appeal
Sorry,
court.
I'm behind you. Which tab?
It's
Tab
tab
9.
9, my lord.
Yes.
Page 56, paragraph 63. It does give a quote at paragraph 63 from the case of Inri B, a judgment of Lord Neuberger.
Yes, this is a very familiar case,
Yes,
most
exactly.
of all to
That's
my
in
lord,
the
but
context
but
of
to all of us. But that's about proportionality.
That's proportionality.
And I mean, you know better than I that there's been a long debate
Yes.
about whether irrationality, the borders of irrationality and proportionality have now effectively merged into a single test, and the orthodox view is still no, they haven't.
I accept that, but but within that context, the courts have given guidance which we say is relevant to this context of Wednesbury irrationality as well. And if you go on to page 65, you'll see reference to the Chief Constable of Greater Manchester Police case.
Paragraph
65, my lord, page 57. And there's observation below letter C about the appellate court sorry, it is equally clear, this is about halfway down, just below C, that for the decision to be wrong, so looking at the test that this court is applying, it is not enough that the appellate court might have arrived at a different evaluation. And we say that there is here, when a court is applying the Wednesbury test...
Yes, forgive me interrupting you, Miss Harrison, forgive me, but I think I must. Paragraph 66, Lord Justice Lewison, having cited that passage, makes it clear that the principle he draws from it is on proportionality. Not
this is a
rationality.
proportionality test, a case, but we say that where the court's application of the legal principle involves evaluation, as it must, on a pure Wednesbury, this is beyond what a reasonable Secretary of State would have done. That is a matter for the court, for the judge below, and this court's approach.
Well, we hear your submission on that. Yep.
Well, I'm grateful.
So do you say it's a bit like unfair dismissal cases where the employment tribunal decides whether or not an employee's acted reasonably, and there's lots of authority saying that you only overturn their decision if it's,
Don't go there. Don't go there. That will be.
No, but I mean that seems to be the analogy you're making.
I think that's a helpful analogy. It's ultimately this. There's got to be some distinction here between a review, which is what we're concerned with, and a rehearing.
Yes, but in a review, you decide binary points of law either way, one way or the other. You can't get out of them by saying the judge reached a reasonable conclusion. You've got to decide whether he's right on the law or not. And that's true whether it's a review or a rehearing or a review. So the real question is, does the fact that this is, as you accept, a rationality test mean that all these authorities about proportionality don't apply? You say, no, they do, because they may not be the same, but they're similar. Yeah. And what I'm putting to you is, no, there's a great gulf fixed between the two.
Well, my submission is that there isn't, because ultimately the formulation of the rationality test, as we see from cases like Johnson, is the ultimate question the court is asking itself, is the decision or the failure to make the decision or to take the action that's complained about justified? And obviously in the context of proportionality, justification has certain elements within it. We now know from looking at cases like Johnson that in formulating the Wednesbury test in practice, one is essentially carrying out a form of assessment of justification by looking at the disadvantages of doing something, of not doing something, and seeing whether the correct balance has been struck. So It isn't formally called proportionality, and there's a distinction, but the task is the same. And I'm wanting to preserve for the first instance judge, who spends a lot of time, clearly as this judge did, with what we respectfully submit is an impeccable judgment, analysing all the facts, which is accepted could only be challenged if one could show that his assessment of the facts is irrational. When it comes then to applying that test of irrationality, that too deserves to on appeal to only be subject to appeal on point of law if he has come to an irrational conclusion on evaluating the rationality of the decision or
okay,
action.
we have the point. Yeah.
I'm grateful. So then that leaves us straight into the key issues in the case. And first of all, and without going into Padfield or rationality, what I would propose to do is to take your lordships through the statutory schemes, and you will have seen from our skeleton argument and indeed from the judgment that whilst we're going to look at the statutory schemes sequentially, ultimately what is clear, and the judge was correct to analyse the scheme overall of immigration control, is when one looks at the Immigration Act 1971 and Section 3C, it has to be looked at in the context also of those hostile environment measures which are in the statutory scheme of the 2014 Act, the 2016 Act, but also in other regulations and policy. They are ultimately the scheme of immigration control. And they interrelate to each other, that's clear, primarily because it has become increasingly essential for the purposes of immigration control for individuals to be able to demonstrate their lawful status in the United Kingdom. Obviously for the purposes of immigration control, are they here lawfully or irregularly? And also, and critically, are they able to access vital services, facilities, benefits that are available to those who are here lawfully, but are not here, but are not available to those who are here irregularly or unlawfully. So there is no question that being able to demonstrate your lawful entitlement to reside and any attendant benefits that go with that is now central to and at the heart of the system of immigration control in the United Kingdom. And obviously the first and primary focus is on Section 3C because of the category of person that we're concerned with, the class of person whose legal status in the United Kingdom is dictated by Section 3C. So whilst I'm going to look at those provisions inevitably first, it is important to bear in mind that we're ultimately going to be looking at how these provisions interrelate with other key elements of immigration control and enforcement. My learned friend has taken you to the provisions of the Immigration Act, but if I could just ask you to take up the legislation again. It's in the core bundle, tab 1. And make this point first of all on general principles. And you'll see that 1 is concerned with those who have a right of abode, which isn't the category of case that we're concerned with. We're concerned with 2. So those not having that right may live, work and settle in the United Kingdom by permission and subject to such regulation and control of their entry into stay and departure from the United Kingdom as imposed under this Act. And so it's important to recognise that from its foundation, Section 1(2) of the Immigration Act confers a right the power to confer the right to both live, work, and settle in the United Kingdom if permission is given. But of course, that will be subject to regulation and control. Section 1(4) provides for the powers to lay rules, and we know from the new college case that this power exists outside of the 3(2) power to make rules relating to entry and stay. But what it does do, and what is important, is that it provides for the Secretary of State to lay down rules in the administration of this Act for regulating entry and stay in the United Kingdom. And it again emphasises that those rules will also include, as we see in the last 3 lines, conditions as to length of stay or otherwise. So that as in 1(2), 4 makes clear that leave that isn't the right of abode is going to be conditional.
Sorry, I'm not sure I follow. Are you suggesting that the rules referred to in 1(4) and 3(2) are different? I mean, it seems to me they're the same rules, aren't they?
Well, that was the position that was Lord Carnwath took in the new college case,
But
and
he wasn't-
they aren't simply related to 3(2). He was in the minority, but
yeah, I mean,
Well, that's what the point, using the minority.
yeah,
yeah.
but
I don't see how they could be, how the 2 sections could be referring to different rules. Surely they're the same rules. Anyway, it doesn't matter for purposes of this case. But
Well,
you submit they're different.
Well, it's not really important to your case, is it? Let's not have more complications than we need.
What's
No.
more important to our case is the interrelationship between the entry, stay, and the conditional nature of
Yes.
it, because it's clear from what we say the learned friend's submission is that he only focuses on the right to stay, by contrast in saying that section 3C is only concerned with overstaying, whereas it's quite clear that for those who have leave granted under this scheme, the right to stay is also closely interrelated to the conditions on which that is granted, and obviously that becomes important when one considers the impact of the hostile environment measures on the ability to enjoy those and to have access to those conditional.
Well, sorry, am I being
provisions that have been made.
slow? But surely conditions don't really matter either. If you've got limited leave, there will almost certainly be some conditions.
Yes.
But the conditions tend to be negative, like not to be allowed to work. Well, we're concerned with the people who don't have that condition, i.e. who can work.
So you will have conditions, express conditions that permit you to
Is that right? To the condition?
or to study, yes, or not to have. Yes, they will.
I
they can
thought
be both ways.
the default. I may just be wrong about this. I thought the default position was that if there isn't a condition limiting your entitlement to work, you can work. But that's wrong, is it?
I'm looking at section 3, subsection 1C. Doesn't that set out what the conditions can be? Or am I completely barking up the wrong tree?
Yes. Well, that's what I was thinking.
That doesn't say conditions including. It says any of the following conditions, namely.
But just on the work.
Restricting.
Yes, the point is that's why I thought you were entitled to work unless there was a condition restricting the right to work.
I'll double check this, but my understanding is that it will be permissive, so that you will know that you have the right to work.
Oh, well, of course you'll know that because there isn't a condition restricting it. But look, I'm just saying, I'm just trying to make this less complicated than it is. I don't think it really matters whether there are conditions. Whatever conditions you have will be preserved by 3C.
Yep.
If you, whatever entitlements you have, whether they depend on conditions or otherwise, will be preserved by 3C. And this case is only about the problems you have in demonstrating your 3C status in a hostile environment thing. So let's not get into red herrings, is really what I'm trying to say.
Well, I suppose the only point of labouring labouring it is that the scheme of the Act for those with limited leave is about the nature of the leave and the duration, but as we've said, about the conditions, and whether they are permissive or they're restricted. The form of leave that is granted, as you've indicated, will be conditional, and will be what we've described them as attendant rights upon the grant of limited leave. Three two is the rule-making power, and 3.3 on page 6 is the power to vary leave. And it's correct that in 3.4 that a person's leave to enter or remain will lapse if he leaves the country unless he returns within the currency of his leave. And then friends made submissions about that as being distinct from section 3C. We will say that it's not a material difference, it simply reflects the nature of the continuing leave. And it is not material to the questions that this court has to address about the circumstances and situation for somebody who doesn't leave the United Kingdom and is remaining in the UK. So then going on to section 3C, which is at tab 10, we say that, first of all, it's clear from the heading of this scheme, of this section, that what it intends to do, as it says effectively on the tin, is continuation of leave pending variation decision. So it's a continuing of the existing leave on condition that you'll see that the person who has limited leave to enter or remain applies to vary. It is made before the leave expires, without the application to vary having been decided, and then obviously 3.2 is key. The leave is extended by virtue of this section during any period when the application for variation is neither decided nor withdrawn. There is an appeal.
Well, you don't need to go through all
that. So, but essentially, it preserves and protects the original leave, which is extended by virtue of this statutory scheme.
It doesn't sound as though you're disagreeing with Mr. Malik.
The difference between us is that his analysis is that the only purpose of section 3C is to protect a person from overstaying. Our submission is that it goes wider than that. It certainly does that, but in addition, it protects the immigration status, which means both the rights to reside, but also any attendant conditions.
Do you mean conditions? You don't?
Or
permissions?
Or permissions. Conditions.
Well, you don't really mean either, do you? You mean benefits. I mean, entitlements. Let's take right to rent.
Yeah.
That's not a condition granted by Section 3. It's not a permission granted by Section 3. Nothing in Section 3 saying you may rent property. It's simply the question of entitlement to rent only comes up because of the hostile environment provisions saying you can't do it unless.
Well, if we take work, because that's the most straightforward.
All right, take work.
And either there's no restriction on it.
Yeah.
Then that therefore means you have, the word that your lordship uses is the right word, entitlement to work. So that is going to be part and parcel of the permission that you have been granted initially, and it will be continued as a result of section.
I'm not sure it is part and parcel of permission you've been granted. Again, I'm wondering whether these points really matter. But if they matter to you, I just want to make sure I've got them right. Clearly, under 3C, unless your right to work was restricted, you had a right to work.
Yeah.
And the hostile environment now means that that's much more difficult to exercise because if you can't demonstrate that you've got leave. But that doesn't mean that you were granted the right to work by Section 3. You weren't. You just granted the right to be in this country, or by 3C. You could, I suppose, say in the case of work, you could possibly say you're entitled to, because I think the actual language of 1(2) is that people not having the right of abode may live, work and settle in the United Kingdom by permission.
Yes.
So you say you can come here, and if your work isn't restricted, you can work here.
Yes, and if you
Yes, okay, in that case, perhaps because of 1(2, you could say it's an entitlement, but it's not. I just don't want to make this more complicated than it needs to be. That wouldn't be true about renting. It wouldn't be true about access to the health service, which there's simply consequences of being in this country.
well,
They're not granted under the Immigration Act.
they're granted insofar as you have been given lawful right to remain in the country.
Yes.
And therefore, and only those who are here irregularly or illegally are denied access.
Yes. No. Well,
that is a different.
Got no problem with that at all.
Yeah, but in some elements are part of your conditions, like work, for example, could be also your entitlement to certain forms of benefit, because that can be excluded, as you can see from 3(1). Little 2, you could have a condition requiring you to maintain and accommodate yourself without recourse to public funds. So that could be a prohibition, but you can, if it's not there, then you have the ability to claim public funds, and you would have that as part of your grant of leave to remain in the United Kingdom. They are attendant rights and are entitlements that are in place as a result of the form of leave that
Well, let's settle for attendant rights as not to have any row about it. Yeah.
We don't have an example in the papers of a document granting leave, do we?
We may have, we'll see. But for Ms Adjei, she had.
It's not,
she was
I don't
able
think
to,
it's exhibited to her statement.
I don't think there's a document, but she certainly had the ability to work, and she also was able to have some recourse to public funds. She was able to claim some form of universal credit. So those were elements of her status, her legal status, her immigration status that involved.
Well, okay, you keep slipping in. I don't have anything to do with her immigration status, but they are attendant rights because she's in this country lawfully.
Yes, which.
And can't we just settle on attendant rights rather than have a theological debate about how you go, where you get them from?
Yes, I'm completely happy about that.
Okay.
The attendant rights are where we would go, or entitlements. That's how we would want to formulate what is continued and extended by virtue of Section 3C.
Yeah.
And that proposition, we say, is clear also from the case law that you have been taken to one of the cases that's relevant, which is the Akinola case. But there is a additional authority that also identifies the purpose of Section 3C. And the judge dealt with this without needing to go through this by reference to all the statutory provisions. But what he did was to look at the development of Section 3C back to 1976 and how it had been developed over time, and in particular, not simply to extend the duration of leave, which is what it originally did to prevent overstaying, but as the case law says, to protect immigration status. That's what the judge found at page 106, paragraph 31. He says it's to protect the bundle of entitlements that were enjoyed by that person as an adjunct to their limited right to remain. So that formulation we would adopt. So it's it's 106. Paragraph 30, and he does that having looked at the developments of the legislative history and purpose beginning at paragraph 27, quoting from referring to explanatory notes to legislation that was implemented in 1999. And we say that that identification of what is, we say, the purpose, the main purpose, even if it might have some other purpose in other bits of the in other bits of the section, that is, as what the judge identified, is to protect the entitlements that were enjoyed by that person as an adjunct to their limited right to remain. We say that reflects case law. For example, the case of JH Zimbabwe, which is in the Core Authorities Bundle, tab 3. Paragraph 35. This is the judgment of the Court of Appeal and the judgment of Lord Justice Richards in a case that concerned the ability to make further applications. But in considering that, the court set out at paragraph 35 what it saw as its understanding of how Section 3C operates.
But this is all completely uncontroversial, isn't it? I mean, and it's directed to a different point, actually. It's directed to the issue of whether you can make a further application, isn't it?
That was the issue in the case.
Yes. So what do we get out of this paragraph that isn't already common ground?
The bottom line is to emphasise that what it is a statutory extension of the original leave.
Yeah. Well. With respect, that's a statement of the obvious, isn't it? Sorry, I'm not trying to be difficult. I'm just trying to see why we're being referred to this. What you find particularly helpful in this? That
I think it's simply to reinforce the point.
Okay.
That it isn't just about overstaying, which is what my learned friend repeatedly said is the purpose. It is doing something much more significant than that, is extending the original leave.
The bundle of entitlements, as the judge put it.
Yes, but the bundle of entitlement point is good, but you don't get it out of here. What you get out of here is exactly the basic point, that it extends the original leave, therefore you're not an overstayer. Not being an overstayer means that your original leave has been extended.
Well, plus where it has those original leave also will have conditions as well, or
they're extended. They're extended as well.
Yes.
Unless you, yeah.
I don't so far detect any disagreement. There's a point about how you characterise what you say as the real purpose. I mean, Mr. Malik accepts that it has the effect of allowing you to continue to enjoy the attendant rights.
Yeah.
He has to accept that, it's obvious. But he says that isn't the primary purpose. The primary purpose is simply to extend the leave, that by itself, which means you're not an overstayer.
Which is why
I didn't think anything on ZH really helped on that. But
insofar as it makes clear, as my lord put to me, that when it says it extends the original leave, it isn't just concerned with preventing overstaying. So
Well,
I'm
it is, but-
labouring the point. I'm
Okay, well, okay,
labouring
well,
it because
anyway, that's fine.
that ultimately becomes important to the purpose. And we see ultimately why that was in the case that my learned friend took you to of Akanola, which is in the same volume at tab 9.
Yes.
212. Because as you saw, although I don't think my learned friend went further, although it's clear, when we go to paragraph 40, what the Court of Appeal, again in the judgment of Sir Stephen Richards, is identifying is the interrelationship between the immigration status, protecting of the immigration status, that's at paragraph 40E, of those with existing leave who have applied for a variation of leave and are awaiting a decision of the Secretary of State or exercising appeal rights. Without an extension of leave in such circumstances, an applicant would be in the UK unlawfully as an overstayer.
Yeah.
And then it goes to the critical point about the disadvantages.
Yes, and
the
my lord picked him up on that.
He did, yes, because it's two purposes. It's both to extend the original leave and also to address the disadvantages that would arise, and in doing so made reference to the Supreme Court's judgment in Pathan, which concerned, if you recall, procedural rights when applications are refused. But in doing so, both Lord Kerr and Lord Wilson took into account the consequences of leave being refused, to include the disadvantages that are essentially the disadvantages of the hostile environment, as well as obviously becoming an overstayer. And you'll see that was expressly said there. How Lord Kerr put it at G is that overstaying also tips a person into the Home Office's hostile environment,
Yep.
refers to July 2006. And then identifies a number of aspects. In there, it's right to rent accommodation, prevented from driving. Lord Wilson also, similarly, this is a quote from 2010, whilst identifying the consequences of overstaying, which is a criminal offence, it would also add that you would be committing a criminal offence if you continue to work. D, cease to be entitled to state benefits, become disqualified from occupying rented accommodation, become subject to the NHS charging provisions, become subject to freezing of funds in his bank account, become subject to revocation of a driving licence, and in various circumstances identified above, become subject to a ban on later entry. So the latter one is obviously related directly or limited to status, but all the other elements from C onwards are concerned with that bundle of entitlements that you have if you've got 3C leave, but which which obviously is the core of the case, you cannot access if you're unable to provide acceptable proof of your lawful status and entitlement to attendant rights in the UK. So, although my learned friend wanted to put weight on and emphasise 41 insofar as it protects an applicant's immigration status. And
I'm
prevents
sorry,
the applicant-
you may be right, I didn't mark that up. Did he refer us to 41?
Yes, he said that shows you what the purpose
Okay,
is.
thank you.
He says
he said it was an incidental benefit, I think.
Yes, he did. Yeah, whereas we say that actually it is clear that it is central to and core to the operation of Section 3C in extending your original leave. It protects your immigration status, which includes protecting you from tipping into the hostile environment measures, as Lord Kerr put it.
But sorry, do you agree with Mr Malik's characterisation of the benefit that's described in para 41 as being an incidental benefit rather than a core purpose?
No, they are the core core purposes of Section 3C.
Right.
But surely that's just what Sir Stephen says they aren't. That's what the final sentence says. I do not think that can be said to be a purpose of the section.
that is in the context of what my learned friend relied upon, which was the Section 10 provision.
What's
Sorry,
the
the
section?
provision relating to accumulating 10 years.
Oh yes, but that's what my lady was asking you about.
Oh, sorry, I thought you were asking me about earlier.
No, I'm so sorry. It's my fault for not being clear. I was asking about paragraph 41.
So where it deals with it also means that you can accumulate the lawful 10 years residence.
Yeah.
Um,
Well, you're stuck with that. So Stephen
Yes.
says that's not a purpose of it, but
no,
I'm not sure it helps Mr. Malik very much either.
Well, I think it doesn't, and it isn't, because we say what is central to the purpose of Section 3C is exactly what's identified as the disadvantages.
Yes.
If you didn't have that form of status.
Yeah. Well, that's the difference between you and Mr. Malik.
Yes,
Yeah.
it is, and we say that if one is looking at, if we were looking at just the C3, the Section 3C in isolation, we would say that is the main and primary purpose. When you put it together with the measures that we're calling the hostile environment measures, which I'll take you to next, it is the overriding purpose, because it is that prevents you from...
That would mean that the overriding purpose had changed. The overriding changed in 2014.
Well, it's always been that purpose. It's always been it has always had that purpose. But I think your lordship put it in discussion that purpose becomes much more acute and critical when you introduce a whole panoply of measures that being able to prove your legal immigration status becomes decisive.
Yes, I mean your real point. I see that your real point. I think perhaps thinking aloud, the best way of putting it is to say Section 3C certainly has the effect of making your continued presence in the UK lawful. You're not an overstayer. You have leave. But that is not just a matter of empty status. It enables you to enjoy life, enjoy full life in the UK, and its purpose is to do that, subject only to any conditions that may have been there in the original leave.
Yes, exactly.
And I see the force of that.
Yeah, and we haven't got it in this quote, but what Lord Wilson ends up saying about the hostile environment measures is that it precludes normal life.
Yes.
And it deliberately intends to do so. That's why it
No, well, I think you say you haven't got it. We have got it. It's between B and C on page 1597. Mr. Patan became
Oh, sorry, yes, it does.
legal,
It's, yes, the
precluded
last
his
paragraph
continued
to 11. Precludes
Yes.
normal life in the UK. And so that's why it is at the heart of immigration control to be able to identify that you are not here irregularly, that you are here with lawful immigration status and entitled to access those rights, services and benefits. It certainly isn't limited in time to 2014 because it was obviously also important previously to be able to identify the fact that you did have a lawful status here, that if you were working you had a permission to do so, or that you weren't prevented from doing so, otherwise you could be guilty of a criminal offence. So you needed to have that. But it's not simply that the hostile environment extended all of that. It also created a system for enforcement of the hostile environment and obviously engaged third parties, employers, landlords,
Hospitals.
banks, obviously some other public authorities, hospitals, student loan services, universities. It put positive obligations on third parties to ensure that the people who they were providing that facility to had a legal entitlement to it. So, and that is a really significant additional aspect of the scheme that was developed after 2014, because it puts duties on them as well
we have
to ascertain, check, verify legal status and entitlement to those services and benefits. So looking then at the, I don't know if the court wants me to go on to the now, or if you're intending to.
No, if that makes a natural break, we're comfortable. I mean, you've got at least an hour under your belt today, or not quite an hour actually. But so you're not. How much tomorrow do you expect to go?
Oh, well, I didn't have a discussion with my learned friend about how much she needs for reply. Maybe it was about half an hour. Yeah, so I think probably until 12:30.
Well, yes, okay. We're not going to be short. It's a 2-day listing, or is it 1.5 hours?
I think it's only one. It's only one. And it's
1.5, is it?
Yeah.
Yes. Well, that should be realistic, I think. Yeah.
Yes, yeah.
We'll cope, I'm sure. Very well. 10:30 tomorrow.
What, by table?